Good morning. Let's continue with the topic, the President of India. Yesterday we have initiated and we have seen some articles and we have understood that there shall be a President of India. And what is the Electoral College, how the President of India will be elected, and what is the secret ballot. So those things we have understood. So let us continue with this. The rest of the articles, we'll see what the Constitution is saying something about the President of India. So let me open the document to you and let me show you the document. Look at this. So this Article 58, this article mentions about the qualifications for the election as a president. What do you mean by this? Anybody who wants to contest in the election, for the position of the president must possess these qualifications. So these are mentioned within the Constitution. Kindly remember, when I was talking to you about the preamble, I used one word called democracy. In a democracy, the people not just have the right to vote, and the people have the right to contest in the elections also. Meaning the citizens have the right to contest in any election. Every political office, including the office of the President of India, is open for all the citizens. So this is what we have understood. That's the reason, if you look at the president also, every citizen with certain qualifications can contest in the election. Winning is separate thing. I am talking about the contesting. For contesting itself, the citizen should have certain qualifications, and those qualifications are mentioned by the Constitution. I'll show you the document now. But otherwise, anybody who wants to contest in the election for the president, he must be a citizen of India. Only the citizens are permitted to contest in the elections of the president and not outsiders. Number two, anybody who wants to contest in the election of the president should have completed 35 years of age. Kindly remember clearly, should have completed 35 years of age means he should be above 35. And while you are writing in the examination, especially in the main examination, you have to mention in the same format, should have completed 35 years of age. Equal to 35 is not permitted. Kindly remember this. This is one place where Indian Constitution and American Constitution differs with respect to the president. America also has got a president, whereas India also has got the president. American Constitution talks about the qualifications of a person to contest in the election for the president, just like that of India. But the difference is that American Constitution says that a person who is not less than 35 years of age is permitted to contest in the elections. Whereas in India, we are saying should have completed 35 years of age. The words 35 is coming into picture, the number, okay. But there is a difference here. In India, he should have completed 35, meaning he should be above 35, and equal to 35 is not permitted in India. Whereas in America, not less than 35 means if he is equal to 35 also he is very much permitted. So this is what the American Constitution says. Now, so when it comes to number 3, the third qualification is that a person who wants to contest in the election of the president should not hold any office of profit. What do you mean by this office of profit? Anybody who is taking the salary from the government is considered to be holding office of profit. For example, here, starting from the level of the president, vice president, prime minister, and everybody, including the government officials like IAS officers, IPS officers, group 1, group 2, everybody, they are taking the salary from the government. Hence, every office is considered to be an office of profit. But In the parliament, there was an act that was passed. The act was called Office of Profit Exemption Act, meaning any office, if it is placed under Office of Profit Exemptions Act, that particular office is considered to be permitted to contest in the election of any other political office. What do you mean by this? For example, here, president is also taking the salary from the government. Vice president is also taking the salary from the government. Similarly, Lok Sabha members, Rajya Sabha members, so many people are taking the salary from the government. But these offices are exempted. These offices are exempted from the Office of Profit. It is because they are kept under the Act, Office of Profit Exemption Act. That's the reason if the sitting president wants to contest in the election again, he can contest in the elections without submitting the resignation letter. Similarly, if the vice president wants to contest in the election as the president, he need not submit the resignation as the vice president because this office has been exempted. Remember this, recently in the year 2012, there was an election to the president of India. In that one, Pranab Mukherjee contested in the election and P.A. Sangma also contested in the election. If you remember the status of these two people during that time, Pranab Mukherjee was a member of the Lok Sabha and P.A. Sangma was the member of an assembly, Meghalaya Assembly. These two persons contested in the election without submitting resignation to their Lok Sabha membership and the Meghalaya Assembly membership respectively. Since they are permitted, it's not a disqualification because the parliament has given the permission. Hence, these offices have been exempted. But once you become an IAS officer or IPS officer, if any government servant wants to contest in the election, they are also permitted, but they have to submit the resignation to their existing job first. Then later they can contest in the elections. That is the meaning of the Office of Profit. Am I clear? Now, and the last one is that, fourth qualification is that, number one, I told you, must be a citizen of India. He should have completed 35 years of age. Number three, should not hold any office of profit. Number four, he should be qualified to be a member of the lower house of the parliament. Can you remember? I am using the word should be qualified to be a member of the lower house of the parliament. That is nothing but the Lok Sabha. But why only Lok Sabha? Why not the Rajya Sabha? Has not been explained by the constitution. Look at this. Qualification of a person to contest for the president election. Look at this, 1, 2, 3, 4. Must be a citizen of India, meaning outsiders, foreigners are not permitted to contest in the election. Should have completed 35 years of age. I told you what is the meaning of this. Should not hold any office of profit. I told you what is the meaning of this. Should be qualified for election as a member of the Lok Sabha. This is very, very important again. Kindly see here. When we speak about the Vice President of India in our future classes, the Constitution also has given qualifications to the Vice President. But the only difference is that instead of should be qualified for the election as a member of the Lok Sabha, while talking about the Vice President, we say should be qualified for election as a member of the Rajya Sabha. But otherwise, 1, 2, 3. First three qualifications are one and the same for both the president and the vice president. When it comes to qualification number 4, president, Lok Sabha, vice president, Rajya Sabha. That's it. That's the only difference. Okay. Now, let me talk to you regarding one point here. Just to give you this information. Look at this article number 71. I am talking to you. This article number 71, it talks about the disputes related to the election of the President of India are challenged only in the Supreme Court, and the decision of the Supreme Court is final and exclusive. Okay. Now, what is the meaning of this? Excuse me. Just stay online. I'll be just back. Wait for a minute. Yeah. See here, so we are talking something about article number 71. From this article 58, we have jumped to article 71. Right? Again, I'll come back to the rest of the articles. But see here, one important point I would like to share with you. Sometimes there may be the election disputes. Look at the article once again. The disputes related to the election of the President of India are challenged only in the Supreme Court. And the decision of the Supreme Court is the final and exclusive. What do you mean by this? So let's try to understand. Look at this, say for example, and of course, one more point. Article 71 is talking not just about the President of India, Vice President of India is also included. You must have read in the newspaper so many times when it comes to the Lok Sabha election, Rajya Sabha election, Assembly election, or Legislative Council election, some disputes will occur. During that time, so we can approach the judiciary and we can file a case. So that case can be filed and the judiciary will look into this. But when it comes to the election dispute of the President and Vice President, that dispute can be challenged only in the Supreme Court. And the conditions are very, very clear. Who can challenge the election of the President? So obviously we will be approaching the judiciary so with a petition. And that petition can be filed only by a member in the Electoral College. Outsiders are not permitted to file any petition with respect to the election of the President of India. Only a member in the Electoral College can file a petition. He can challenge it. Number two, only a member who contested in the election and who got defeated can challenge the same thing. But once the judiciary, once the Supreme Court gives a judgment, and the judgment shall be final. For example, here in the year 2012, when the election was conducted, two people have contested. Of course, 42 members have submitted the nomination papers, but 40 nomination papers were rejected. Only two people were left in the fray. One was Pranab Mukherjee, the present President of India, and another person was this P.A. Sangma. As usual, the nomination papers were submitted, and both the leaders have submitted the nomination papers. And once the nomination is over, the dispute has been started, and P.A. Sangma started claiming that the nomination of Pranab Mukherjee should be rejected because he was holding an office of profit at the time of nomination for the election of the president. But what exactly happened during that time is that Number one, if you remember, the Pranab Mukherjee was the finance minister of India during that time. At the same time, he was also the leader of the Lok Sabha. Kindly remember this one. We have a leader for the Lok Sabha and a leader for the Rajya Sabha. Generally, wherever the Prime Minister has the membership, for that house, the Prime Minister will become the leader of the house. Today, for Lok Sabha, Narendra Modi is the leader of the Lok Sabha because Narendra Modi is a member of the Lok Sabha. Similarly, in the Rajya Sabha, Arun Jaitley is the leader of the Rajya Sabha because Arun Jaitley is a member of the so-called Rajya Sabha. But forget about who is the leader of house in one house. But I'm very particular about the Prime Minister. The Prime Minister, wherever he has the membership, he will automatically become the leader of the concerned house. So today it is Narendra Modi for the Lok Sabha. But previously, if you look at this one, Dr. Manmohan Singh was the Prime Minister of India for 10 years. But he was a member of the Rajya Sabha. Then he became the leader of the house, leader of the Rajya Sabha. And in the other house that is called Lok Sabha, the Prime Minister can decide who can be the leader of the house. And during that time, Pranab Mukherjee was appointed as the leader of the house in the Lok Sabha because Manmohan Singh is there in some other house, Rajya Sabha. So that varies from situation to situation. Now, so Pranab Mukherjee was the leader of the house. He was also the finance minister. But just before submitting the nomination form, Pranab Mukherjee has submitted resignation to the ministership. He was a finance minister. He submitted the resignation. But only a minister can be the leader of the house. And Pranab Mukherjee, the moment he submitted resignation to the finance ministry as the finance minister, he is also no more as the leader of the house. Hence, there is no dispute. But this was also made a dispute by P.A. Sangma and other members. Number one. Number two, at the time of submission of the nomination form, Pranab Mukherjee was also the chairman for Indian Statistical Institution that is located in Calcutta. So, and this is considered to be the office of profits. And once the election was over, immediately P.A. Sangma has approached the judiciary, that is the Supreme Court, and challenged the election of the president, Pranab Mukherjee. And the Supreme Court has constituted a constitutional bench. Kindly remember, when I'm using the word bench here, it is nothing but a group of judges. And whenever I'm using the word constitutional bench, in that group, minimum 5 judges will be there. It will be constituted by the Chief Justice of India, and minimum 5 judges will be there in the constitutional bench. And that, so what is the advantage? Minimum 5 judges. It may be 5, 7, 9, like this. If the 5 judges are there, instead of 1, 2 judges, all the 5 judges will look into this. And over a period of time, they will give the verdict. If all 5 are giving the same verdict, there is no dispute. In case of difference of opinion, the majority opinion will be taken into consideration. Similarly, in the case of Pranab Mukherjee's election as the President of India, the Constitutional Bench has given a verdict. And 3 judges have supported the election. 3 judges have supported the election of the Pranab Mukherjee, and the remaining 2 judges said that it needs further inquiry. But the judgment that is given by the Supreme Court shall be final. Hence, the 3 judges' verdict was taken into consideration. The 3 judges said very clearly that the moment he submitted resignation as the Minister for Finance, he is no more the leader of the house. Then dispute 1 number is no more valid. When it comes to the chairmanship of the Indian Statistical Institution, The court observed that Pranab Mukherjee, when he is the chairman of the Indian Statistical Institution, he never took even a single rupee as the honor of for the payments. He did not take any salary and he did not receive any honor in the form of monetary benefits. And for that matter, he never used the vehicle that has been provided by Indian Statistical Institution. For that matter, he never used even a driver that was provided by Indian Statistical Institution. And above all, the court observed that whatever the office of profit you are talking about, chairman for Indian Statistical Institution, this is already kept in Office of Profit Exemptions Act. Hence, all the allegations that are framed are considered to be nullified, and the election of the president, Pranab Mukherjee as the president, was upheld. So this is what happened during that time. That is the reason why Pranab Mukherjee was continued to be the president of India. But it was a dispute, and kindly, depending on the question, kindly please mention in the examination, in main examination. Look at this. The disputes related to the election of the president of India are challenged only in Supreme Court, and the decision of the Supreme Court shall be final. This is the point for me. Next, let me go to the other lines. Look at this. I've given some points. On August 21st, 2012, right? This is the dispute. Just now I spoke to you. Just read these lines. On August 21st, 2012, P.A. Sangma, the defeated National Democratic Alliance candidate, moved the Supreme Court challenging the election of Pranab Mukherjee as the president, contending that he was holding offices of profit and hence not eligible to contest for the post. And the contention was that Pranab Mukherjee was holding the office of profit like leader of the Lok Sabha and the chairman of Indian Statistical Institute. The argument is that the Lok Sabha website was showing Pranab Mukherjee as the leader of the Lok Sabha even after submitting the nomination papers and continued up to July 30th, 2012. Right? Look at this. So one point, can you see here? Article 71 also includes the disputes related to the election of the office of the vice president also. Let me come to this after some time. But see here, so just remember this point. When this particular case was filed in the Supreme Court verdict came in favor of. So 3 judges verdict came in favor of Pranab Mukherjee. That is the reason why he is continued to be the president of India. Am I clear? Now, some more points here. Whenever anybody wants to contest in the election of the president, there should be a security deposit. And that security deposit is the 15,000 rupees. Important. Anybody who wants to contest in the election must deposit some amount. That deposit is called security deposit. And generally, once the election is over, that security deposit will be given back to the candidates, but the candidate must get at least 1/6 of the votes polled. Otherwise, the security deposit will be forfeited and it will not be given back to the candidate. Am I clear? This is important point. Kindly remember, the security deposit is 15,000 rupees. And now, anybody who wants to contest in the election here as the president of India, they have to submit the nomination forms. Nomination form is nothing but the application form. But here we use the word nomination form. In examination, it is application form. In the election, it is called the nomination form. Just remember this. And anybody who is submitting the nomination form, he should be supported by some of the members. And these members must be the members of the electoral college. Yesterday, I told you who are the members in the electoral college. That support is nothing but out of this total members here, at least 50 plus 50 members must support a candidate who is contesting in the election. 50 plus 50 means 100 members. 50 members should sign as a proposers and other 50 members should sign as a seconders. 50 proposers and 50 seconders must sign, otherwise that will become an invalid nomination form and the election commission will reject those nomination forms. Look at this. In the year 2012 election, 42 candidates have submitted their nomination forms. Not 1, 2, 42 members have submitted the nomination forms. And out of that one, election commission has rejected 40 nomination forms. It is because these 40 nomination forms did not contain 50 plus 50 proposers and seconders. That is the reason at the end of the day, only 2 persons were left in fray. Pranab Mukherjee and also P.A. Sangma. This is what happens. Am I clear? Kindly remember this. Next, I'm opening the document again. Look at this. 50 plus 50, 50 proposers and 50 electors. Kindly remember, you are coming across with the word, this is called the elector. Elector is nothing but a voter. Voter is a person who is a member of the electoral college. Hence, it should be signed only by the members who are present in the electoral college and not outsiders. Look at this. Before 1998, the proposers were 10 and seconders. It's a little bit here, but otherwise presently it is the 50 plus 50. Now, look at this. Each nomination paper should be accompanied by a certified copy of the entry relating to the candidate in the electoral roll for the parliamentary constituency in which the candidate is registered as an elector. Right. Apart from this one, the person who is contesting the election should also be a registered voter in one of the parliamentary constituencies. So this is a condition. Without being a registered voter in any of the parliamentary constituency, so he cannot contest in the elections. Look at this. Next one we are talking about article number 59. Let me show you the document here. This article 59 talks about the conditions of the office of the president. What do you mean by this? The conditions are nothing but the president shall not be a member of any house of a union or the state legislature. Meaning, if a person who is already a president of India should not be a member of any house at the union or at the state legislature. But let me tell you one point. By looking at this statement, kindly don't get confused here. A person who is already a member of the Lok Sabha or Rajya Sabha or the state legislature, he is very much permitted to contest in the election. In the beginning of today's class only, I made it very clear. Being a member of the Lok Sabha, Pranab Mukherjee contested in the election. Being a member of the Meghalaya Assembly, P.A. Sangma contested in the election. But what happened? Even after the election also, P.A. Sangma continued to be a member of the Meghalaya Assembly because he was defeated. But when it comes to Pranab Mukherjee, since he got elected as the President of India, the moment he is elected, his previous position is considered to be vacated. Once he becomes the President of India, his Lok Sabha membership was automatically considered to be vacated. This is a very, very important point. Kindly remember this one. He need not submit the resignation letter, but that is considered to be vacated automatically. This is what happened with Pranab Mukherjee. That is the reason once the vacancy was created in the Lok Sabha, election has to be conducted. And Pranab Mukherjee's son contested in that election. And again, he got elected as the member of the Lok Sabha. This is what happened in the year 2012. Is it clear? Meaning, at the same time, a person cannot be the president and also a member in the legislature. Constitution is not permitting. But being a member of the Lok Sabha, Rajya Sabha, or assemblies or legislative council, a person is still permitted to contest in the election. But the moment he gets elected to the office of the president, his previous position is considered to be vacated. Am I clear? Now, let me open the document now. Look at this. He shall not hold any office of profit. The president shall be entitled to the free use of his official residence. Kindly look at this. The official residence of the president is called a Rashtrapati Bhavan. He can use it freely here, meaning that is a rent-free accommodation. By looking at the dignity of the office of the president, since it is the highest office, certain privileges have been provided to the office of the president. Next one. Such as the emoluments, allowances, and privileges, and all these are determined by the law. Kindly remember this one. Whatever we are speaking here, everything can be decided by the parliament by law. I told you already, whenever I am using the word by law means introducing a bill, passing a bill, and making it an act. At the same time, look at this. The president has been provided with the free travel, and he has been provided with the secretarial staff, free telephone, free water, electricity, rent-free furnished accommodation. That is called the Rashtrapati Bhavan. By looking at the dignity of the office, all these have been provided. Look at this. When it comes to this, the medication, pension to the president, right to the president's spouse, if the president dies in the office or after retirement, so many benefits have been given to him. Right? Now look at this. Right now, the salary of the president is 1,50,000 rupees. 1,50,000 rupees, it's the president's salary. And his pension is equal to 50% of the salary. Pension is a benefit that is given to the president after his retirement. Once 5 years are over, the president is entitled to the benefit of pension, and that is equal to 50% of the salary. Hence, the retired president is getting 75,000 rupees per month as the so-called the pension. Okay, and just a moment again. We'll be just back. Wait for a minute again. So like this, so many benefits are given to the so-called the president, right? Now, so we're talking about next article, that is article number 60. Can you remember article 59 talks about the conditions. Article number 60, I'm showing it to you. This talks about the vote or affirmation by the president. Kindly remember, there's one important point I would like to tell you. Let it be any office in the government, maybe the president, vice president, prime minister, or anybody, he must take the oath of office. And the constitution asks that when it comes to the oath of office, for the president, it should be administered by the Chief Justice of India. Kindly see here, there is no person above the office of the president. Since the president office is the highest one, Constitution has made a provision saying that even the president should also take the oath of office, and that will be administered by the Chief Justice of India. Sometimes here in India, what happens is that whenever the president is not available, the duties of the the duties of the president are discharged by somebody else. Let it be anybody. If he is acting as the president for even for one day, he should also take the oath of office. Kindly remember. Meaning, just like that, nobody is supposed to perform the functions of the president. Okay? And this oath of office is administered by the Chief Justice of India. That is the point I would like to make, and that is what is mentioned in the Constitution under Article number 60. Now, let me show you the document again. Look at this. Look at this. Oath. The oath of office is administered by the Chief Justice of India, and in his absence, the senior most judge of the Supreme Court. Maybe because of some reason, if the Chief Justice of India is not available, then again, no issues here. The senior most judge of the Supreme Court will be administering the oath of office to the President of India. Look at this. Acting president should also take a similar type of oath. Let it be for 1 day, 1 month, or 2 months. Even the acting president should also take the oath of office. That is the point. And when it comes to the president takes the oath to preserve, protect, and defend the Constitution and the law. He will take the oath to preserve, protect, and defend. Kindly remember these 3 words. It was a question in the examination. How he will take the oath? He will take the oath to preserve, protect, and defend the Constitution and the law. Look at this. This point we have seen already. The salary and other allowances are determined by the Parliament from time to time. And the salary and other allowances of the president cannot be diminished during the term of office, meaning that should not be varied to his disadvantage. So this is a very, very common point for all the offices in India. So this is salary or other allowances. So they are expected to be increased. So if it is increased, you are giving some advantages to that office, but they are not expected to be diminished or reduced. Okay. Now, these points I told you already. The salary, right now the salary is 1,50,000 rupees, and right now the pension is 9 lakh rupees. Okay, this is the per annum. Kindly remember, salary I have written as 1,50,000 rupees per month. But when it comes to pension, so I made it very clear, it is per annum, meaning 75,000 rupees per month, and per annum it is coming to 9 lakh rupees. So whenever the president wants to resign, yes, the president can resign, and the resignation letter will be addressed to the Vice President of India. Kindly remember, this is one important point. See here, for our information, let me make one point very clear. Look at this, simple. Just remember this. This is a very frequently asked question in so many examinations. The president submits a resignation letter to the vice president. Just kindly remember this. In the similar manner, whenever the vice president wants to submit the resignation letter, he will submit to the so-called president. Just remember this. It is just like give and take here. If the president wants to submit the resignation letter, that will be submitted to the vice president. If the vice president wants to submit the resignation letter, that will be submitted to the president. Just remember this point, okay? Next, when it comes to Article 61, this Article 61 talks about the procedure for impeachment of the president. I told you already some time back that the Constitution has provided a mechanism where the president can be removed. I was telling you even during when we are talking about the sources of the Indian Constitution. The impeachment procedure of the president was borrowed from American Constitution. So what is the meaning of this? So we have a president and the president term is 5 years. Because of any reason, if we want to remove the president of India, the Constitution has provided a mechanism, and only that procedure that is available in the Constitution can be used for removing the president. In independent India, we don't have any practical example because no president has been removed so far. But the procedure is still available. So let me explain what exactly is that procedure. The Constitution mentioned under this article that the president can be impeached only on the grounds of the violation of the Constitution. But what is the meaning of the violation of the Constitution was not explained by the Constitution. But if the situation demands tomorrow to remove the president, yes, the Constitution has provided a procedure. Kindly remember, number one, the reason should be violation of the Constitution. Number two, this procedure looks so simple for removing the president, but it is deliberately made a very complicated one. It was made so complicated only to give security of tenure. Otherwise, if the president is made to be there in the office on the mercy of the government of the day, it becomes it will be an insult to the highest office in the country. But the procedure, though looks simple, now I'll tell you, but it is really a complicated one. And if you want to remove the president of India, the procedure can be initiated in either of the houses of the parliament. Either of the houses means the procedure can be initiated in the either Lok Sabha or in the Rajya Sabha. Kindly remember, yesterday I was talking to you regarding the election of the president. During that time, I was speaking to you about the electoral college. There I told you elected members of the Lok Sabha, elected members of the Rajya Sabha, and elected members of the state legislative assemblies plus elected members of assemblies of Delhi and Pondicherry will vote in the election of the president. There we made it very clear, nominated members were not permitted to vote in the election of the president. But when it comes to the removal, the Constitution has removed, the Constitution has not permitted legislative assemblies to take part in the impeachment procedure. That's the reason why I'm just removing the assemblies. And I'm left only with the Lok Sabha and Rajya Sabha. When it comes to the election, only elected members were permitted. But when it comes to the removal, all the members of the Lok Sabha and all the members of the Rajya Sabha were permitted. Am I clear? It's an important point. Kindly remember this. So meaning 545 plus 245 members will be deciding whether the president should be removed or not. And when it comes to the, you should have a reason. If you want to remove the president of India, you should have a reason. That is nothing but you have to frame the charges against the president. And those charges must be signed by at least 1/4 of the members of the House. If it is Lok Sabha, out of 545, 1/4 members must sign, and a notice should be given to the President of India 14 days in advance. The Constitution said very clearly, 14 days advance notice should be given to the President. And after 14 days, the procedure may be initiated in the concerned House. And again, there will be a discussion, there will be a voting in the House. And in that voting, if it is passed by 2/3 of the total, then the procedure in House number 1 is considered to be over. Kindly see here, I am using the words 2/3 of the total here. What is the meaning of the 2/3? I told you already in the previous classes, that is nothing but the special majority. But here, I am using the words 2/3 of the total. While talking about the special majority, I did not use the word total here. But when it comes to the special, two-thirds majority of the total means on that particular day, how many members are present in the house, we are least bothered. Maybe 500, maybe 400, or some other number. But when it comes to the acceptance, it should be accepted by minimum two-thirds of the total, then only the procedure is considered to be completed. If it is accepted by house number 1, then only the scene will be shifted to the second house. And the second house will be acting as a investigating authority. Charges are framed by the first house. Investigation is made by the second house. And after investigation, so during the investigation, the president may be called to the house. The president may be questioned. The president may attend or may appear on his own, or president may send his representatives. But whatever it is, once the questioning is over, again there will be a voting. In that voting, if it is again passed by two-thirds of the total, the moment that it is passed, the president stands impeached. Very, 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 very important. But in independent India, never we have used these provisions. In most of the cases, there was a cordial relation between the Prime Minister and the President of India. That is the reason why it was really a smooth functioning during that time. Am I clear? So now I'll show you the document. I'll explain this to you. Once again, look at the points now. Impeachment. The President can be impeached from the office by a process of impeachment for violation of the Constitution. Important. The charges can be initiated by any house of the parliament. I told you just now. Look at this. All the members of the Lok Sabha and Rajya Sabha take part in the impeachment process of the president. In the brackets I have written, both elected and nominated. At the time of election, only elected members are coming into picture. But at the time of removal, all the members are coming into the picture to vote for removing the president. Now, assembly members are not permitted to take part in the impeachment process of the president. Next one, the charges should be signed by 1/4 of the members of the house. Look at this. 14 days advance notice is given to the president. And after it is passed by two-thirds of the total membership of the house, then it is sent to the other house. Very, very important. I told you what is the meaning of this. Next one. If the other house also passes the same with the two-thirds majority of the total, then the president stands impeached. So this is the meaning of this one. Look at this. No Indian president has been impeached so far. Clear? Now, hope you have followed this one. Now we have one more article. This article talks about the vacancy in the office of the president. What do you mean by this vacancy here? So whenever we talk about the vacancy, look at this. Just scrolling here. Now look at this. Whenever I am talking about the vacancy, look at this. The vacancy in the office occurs. Kindly see here, I am talking about a situation where the president is not available. The vacancy will occur because of the expiry of a tenure of 5 years. Once 5 years are over, there is a vacancy. Or the president might have submitted the resignation letter, or the president might have been impeached, or there may be the death of the president, or otherwise. Kindly see here, let me tell you these points now. So when it comes to the constitution, it made it very, very clear. The vacancy is occurring because of various reasons. Either the term 5 years is over, or the president might have died, or the president might have submitted the resignation letter, or the president might have been impeached, or otherwise we are saying. When it comes to the otherwise, I explained you what is article number 71. Under article number 71, the Supreme Court may declare the election of the president as invalid. If the Supreme Court declares so, then the president election will be nullified. He will be no more the president. Am I clear? So various reasons are there in the constitution where it can be the so-called the vacancy. And kindly remember, because of any of these 5 reasons, if the vacancy occurs, during that time, the election must be conducted within a period of 6 months. And for this particular period, the vice president will be acting as the president of India. Here I am using the word, the vice president is acting as the president of India. Similarly, sometimes what happens is that the president may be ill, his health is not good, or the president may be out of country. So during that time, the president is not performing his duties because he is out for various reasons. Even during that time also, the vice president will be discharging the functions as the president of India. In case of death, impeachment, resignation, or otherwise, the vice president will be acting as the president. In case the president is ill or out of station, during that time, the vice president is discharging the functions of the president. So every mechanism has been provided by the constitution. Meaning this is the highest office in the country. This office is not expected to be vacant at any given point of time. Hence, the constitution has made various arrangements. Am I clear? Kindly see here. So today, the orders are issued by the Rashtrapati Bhavan, signed by the President of India. Every bill will become an act only with the signature of the President. We know all the points. But if the President is not there, if the Vice President is acting as a President, or if the Vice President is discharging the functions of the President, then during that time, every activity that is supposed to be performed by the President of India will be performed by the Vice President. And the validity is the same because this gentleman is functioning in the capacity as the President of India. During that time, if the President of India signs a bill, that bill will become a law. He is not signing in the capacity as a Vice President, he is signing in the capacity as the President of India. Am I clear? Very, 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 very important. And in the absence of both President and the Vice President, then the Chief Justice of India will be acting as the President. It will happen very rarely. Of course, it happened in India one time. In the year 1969, the President was Zakir Hussain. In fact, he was elected in the year 1967. And unfortunately, within a period of 2 years, Zakir Hussain passed away. At that time, V.V. Giri was the Vice President of India. And he started acting as the President of India. Just now I told you, because of the death of the President, if there is a vacancy, election has to be conducted within 6 months. And the Election Commission has given the notification for conducting the election. During that time, the Vice President, the so-called, who is acting as a President, Mr. V.V. Giri, he wanted to contest in the elections and he submitted the resignation letter. But kindly remember, in the beginning of the class, I told you, the office of the Vice President is not an office of profit under the law. Hence, without resignation also, V.V. Giri would have contested in the election as the President. But according to him, Mr. V.V. Giri, it was not proper to him to contest in the election of the President by holding the office of the Vice President. Based on his own values, personal values, he submitted the resignation letter and he stepped aside. So that was a situation in India where there was no President and there was no Vice President. During that time, the Chief Justice of India, Justice Muhammad Hidayatullah, he acted as the president of India for a period of time. Meanwhile, the election was held and VV Giri got elected as a president and he became the president of India. During that time, kindly remember, when the Chief Justice of India is acting as the President of India, the responsibilities of the Chief Justice of India will be taken over by the senior most judge in the Supreme Court. Okay? And as the Vice President, anybody who is the Vice President, we have discussed already, his responsibilities are acting as the ex officio chairman of the Rajya Sabha. Because this gentleman, Vice President, he is acting as the President, he cannot function as the chairman of the Rajya Sabha. During that time, the deputy chairman of the Rajya Sabha will be acting as a chairman of the Rajya Sabha till the person comes back. Every arrangement has been made so that there will not be any disturbance to any office. This is what happens. Am I clear? So kindly remember all these points and revise each and every point. Very, very important. In every examination, at least one question, two questions are coming in the objective type from the president. And when it comes to the main examination also, very frequently these questions are being asked in the examination. And the rest of the points we'll see tomorrow morning at 5 o'clock. So thank you so much for being with me this morning. I'll take leave of you now. I wish you all the very, very best and have a very, very good day. Thank you so much.